It's chilly in here. I feel like my nose is sniffling. Anna, you know what I did on that MTRP previously? That
You didn't.
I didn't do it. I'm so sorry.
It's okay. We made a note.
Okay, I'm doing it on this one.
Thank you.
All right, so are you Quindarius Moore?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Moore, in cause number 23, DCCR 1237, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 5th of 2023 for the state jail felony offense of unauthorized use of a vehicle, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
Looks like y'all have elected to go on just 1, 2, and 3.
That's right, Judge. Still would abandon the remaining counts, allegations.
Looks like July 24th was quite the day over in Louisiana, wasn't it?
No, ma'am.
It wasn't, was it? Good grief. All right, so the state's elected to proceed on counts 1 through 3. Count 1 alleges you violated your probation by committing the offense of simple burglary, July 24th, 2024 in Calcasieu Parish, Louisiana. And is that true or not true?
True.
Count 2 alleges that you committed the offense of simple burglary, felony on July 24th of 2024 in Calcasieu Parish, Louisiana. No, well, this one just says, Calcasieu Parish, Louisiana also. It looks like these are different. This is, must be different units of the same
Different
place.
victims, Your Honor.
They're all, it's like 700 Henning Drive, number 65, number 67, and number 68. So it must have been different units of the same place. So count 2 is to unit number 67. And is that true or not true?
It's true.
Count 3 alleges that you committed the offense of simple burglary July 24th, 2024, and that one is to 68. Is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted any evidence that Mr. Moore is not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty of unauthorized use of a vehicle and find you guilty of that offense. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. Good luck to you, sir. You can go back with the bailiff. Good morning.
Good morning.
You're Emilio Rodriguez?
Yeah.
And I'm going to take judicial notice of the court's file in Mr. Rodriguez's case. And Mr. Rodriguez was examined for competency to stand trial by Dr. Crapon. Received that report, which is dated February 12th of 2025. And in that report, the finding is that Mr. Rodriguez is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Not from the state.
All right, then I am going to find at this time, based on that report, that Mr. Rodriguez is competent to stand trial. This is at MTRP, so what's the announcement, Mr.
Yes, Judge,
Mitchell?
we're going to plead true.
Okay, is there any agreement?
No, Judge,
Okay,
the agreement's just to come to you and
Sure.
have arguments, so.
okay, let me get that pulled up then. Mr. Rodriguez, the best you can, would you raise your right hand for me? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Mr. Mitchell, will your client waive the formal reading of the motion?
Yes, Judge.
Mr. Mitchell, I have a motion to revoke your unadjudicated probation.
Mr. Rodriguez.
I'm sorry, Mr. Rodriguez. No, I do not have a motion to revoke yours. Not that you're on one, just a joke. Mr. Rodriguez, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation back on April 15th of 2024 for assault of a public servant, and that was a 5-year deferred probation. Is that correct?
It's not.
This motion says that you violated your probation. Count 1 alleges that you committed the offense of an offensive touch on June 24th of 2024. And is that true or not true?
It's true.
Count 2 alleges that you failed to conduct yourself in a courteous and professional manner with the probation court officers and staff, probation officers. And is that true or not true?
I don't understand.
So it's saying that you did not conduct yourself properly when you were at probation by inappropriately touching Ms. Willis and who was with the Bella Mente Counseling. And is that true or not true?
Yes,
Okay, that's true.
true.
All right, so did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
I do.
And did you plead true to those counts because you actually did what they said you did?
It's true.
All right. I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case. I'm going to ask probation to do an update, see how things are going, what possibly can be done, or what's going on in the jail at this point, and then we'll come back later for sentencing. If there's anything that's important, Mr. Rodriguez, make sure you visit with Mr. Mitchell about that. He'll let me know and present your information to me on your behalf when we come back.
Yes, ma'am.
All right, thank you. You can go back with the bailiff.
Thanks.
May I be dismissed, Your Honor?
He needs to be printed.
Okay. Good morning, Your Honor.
Good morning.
Good morning, sir.
Good morning. Are you Dylan Blackwell? And Mr. Blackwell previously was here, entered a plea of guilty to sexual assault of a child. The agreement was for a cap of 15 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor.
All right, Mr. Vasquez, you may proceed.
Well, Judge, you already know what I'm going to plead for. Delon was 21 when this occurred, when the girl was not yet 17. She was 6 or 7 months shy of 17. It was very stupid and irresponsible and hormonally insane. I don't know if he's been living underneath a rock or what for the last 5 years, but he should know someone that age cannot consent.
Let me ask Mr. Hoffpower, or what I have read in the pre-sentence report, and there's no statements of interested parties, and so the victim or her family, no one responded to this. what I'm reading is that the girl I guess here's my question. I don't see any allegations that this was not consensual. Now, I obviously understand that legally she cannot consent. So I'm not talking about legally, I'm talking about factually consensual. It appears to me as though it was factually a consensual party in. They actually reached out, the girls, to Mr. Blackwell, if I'm correct. Go see alcohol, want to party, and all the things happened consensually, factually. Am I correct on that?
That's the understanding. Now, if we go by just the defendant's account, which is in the PSI.
We don't have another account. And so if we don't have another account, then I guess my question is, why are we even talking about, and let me tell you something, Mr. Blackwell, what you did was absolutely stupid. But when we've got a 21-year-old and a 16-year-old, when the 16-year-old's the one that reached out to go party and do these things, do I feel like there needs to be some punishment, some rehabilitation, some better judgment calls? 1,000%. Do I feel like I'm going to send this young man to prison for that? I mean, Mr. Hoffpower, I mean, is that what you're asking?
Your Honor, we just, with the cap, all we have, I can't speak to why they did not respond to probation. We were ready for trial. If you remember this case, we brought this to, we were ready to go to trial.
Right.
And so when we notified them about when the sentencing was. Now, the account by the defendant is, there's still no attrition in regards to whether or not that they can't consent, even when he knows she can't consent, he acts like it was what the court's acting like it was. He picked up someone and didn't check with her how old she was. And it seems to me that he's not acting like he did something wrong. It's just, I just picked up a girl off of Instagram and brought him out to party. And I don't see where there's any, acknowledgement of guilt in this. And I believe we're here, he pled guilty.
Well, he pled guilty and could go to prison for 15 years, so that's some acknowledgement, I would think.
Now,
I mean,
also included in this, Judge, is the court has received.
I have that, and I'm going to get to that in just a minute.
As to the other, I can't speak to, we've given them notice to when the hearing is, and they've been called by probation.
Okay.
And that was the plea, was the cap to avoid a trial. So that's what happened. And the state is just leaving it for the court to make that decision. We're not arguing forcefully for prison time. We're just leaving it at the discretion of the court.
I mean, no matter what, Mr. Blackwell now is going to have to register as a sex offender, going to have to go through treatment, all that stuff is going to be out there. And I don't want anyone to think that what I'm saying is that, Mr. Blackwell, that I think what you did was okay in any way, because it's not. I just don't think this is the case and this is the set of facts unless there's something else that I'm missing for some lengthy prison sentence when, we're not talking about a 12 or a 13-year-old. We're talking about someone that was almost legally able to consent, reaching out. And
I think the court needs to know there is one other factor that adds to this, that videos of this act were posted online. So a 16-year-old in sexual acts were posted
Right.
online in this case.
But who did that?
That is
wasn't
something that was to be proven whether or not,
who posted
It was
what,
posted.
and yeah.
but
That's,
it was posted.
I mean, it's